Hello and welcome to Narayana Eyes. I'm Pratik, your faculty for Daily News Analysis. Now, as part of our Daily News Analysis, we shall be discussing 5 important topics from the Hindu and the Indian Express. So, let's have a quick idea about the topics that we are going to discuss in today's session. The first article is taken from Hindu, page number 9. The article highlights the importance of judicial intervention. Now, the Supreme Court is going to assess the constitutional validity of the Citizenship Amendment Act, right? Then, the second article is taken from Indian Express, page number 30. Now, the Supreme Court here is revisiting the 1995 order where it highlighted or where it declared that the doctors can be sued for faulty services in consumer courts. Now, this reconsideration stems from the fact that the recent ruling of the Supreme Court held that professionals like lawyers cannot be sued in consumer courts for faulty services. The third article is taken from Indian Express, page number 15. Here, the Competition Commission of India chairperson highlighted concerns about the digital market concentration, right? For example, barriers to entry, platform neutrality, algorithm collusion, which can stifle the competition, right? The fourth article is taken from Indian Express, page number 15. Now, this article talks about the EV market dynamics in India. The author of the article tries to highlight that how competition and level playing field is extremely important for the success of EVs in India. The fifth article is taken from Indian Express, page number 13. Now, in Indian city of Kochi, there will be a meeting of Antarctica Treaty, right? So here, the topics to be discussed are peaceful governance, then sustainable resource management and regulation of tourism. So these are the 5 topics that we shall be discussing, and in the end we shall be discussing few practice questions so that it will understand or it will help you to understand the type of questions that can be asked in the UPSC examination. So let's get started. Students, the title of the first topic is Critical Times Call for Strong Judicial Adjudication. So in this context, you need to understand what you mean by judicial adjudication, and you can map this topic under GS paper 2 under important aspects of governance, transparency and accountability. So let's go through a previous year question. Now, question is, in India, judicial review implies. Now, take a pause the video and try to read all the options and see for yourself which option you find it correct. So again, judicial review implies power of the judiciary to pronounce upon the constitutionality of laws and executive orders. Then the option B is power of the judiciary to question the wisdom of the laws enacted by the legislature. C, the power of the judiciary to review all the legislative enactments before they are assented by the President. And 4, the power of the judiciary to review its own judgments given earlier in similar or different cases. So, what is judicial review? The Parliament makes the laws or the rules. Now, once the Parliament makes the laws or rules, it is up to judiciary to decide the constitutionality of that particular law or rule. So, judicial review is the power given to judiciary to interpret the constitutionality of the law. So, going by all the 4 options, option A seems to be the correct answer, right? So, let's try to understand the context. The context is the Supreme Court will soon assess the law made by the Parliament. And which law? It is the Citizenship Amendment Act law. So, the author tries to highlight that how it is important for the judiciary to intervene timely in order to uphold the constitutional democracy. So, first let's try to understand what is Citizenship Amendment Act of 2019. Now, it provides a pathway for the undocumented migrants for Indian citizenship. So, the undocumented migrants belonging to 6 religious minorities, right? These are the 6 religious minorities. They can now get Indian citizenship. So here, if you see, the Muslims are excluded from the list. Again, the CA reduces the requirement for citizenship for eligibility from 11 years to 5 years. So we have different ways through which one can seek India's citizenship. For example, we have naturalization, birth, descent, registration. So under naturalization, a person requires 11 years before he can get India's citizenship. Now, this law is reducing that period from 11 years to 5 years. So, as it excludes Muslims, it has led to controversy in our country, right? So, now what are the concerns over CA rules? One, it excludes the Muslims, which means it violates the secular principle. You might ask me why and how does it violate the secular principle? Now, again, secularism is one of the founding principles of a constitution. Now, here, the law is trying to give citizenship on the basis of religion, and the constitution states that no person will be discriminated on the basis of religion, right? So, the another concern over the CA rules being that what of the people whose application is rejected? These people would be sent to detention centers, and the investigative agency or the National Investigation Agency and intelligence agencies has reported that the radical agencies or the terrorist outfits are recruiting people from the detention centers. So, this can also pose a big security risk to our country, right? Then again, the act is criticized for discriminating on religious grounds, targeting a particular religion. That's the reason the author wants that there should be judicial scrutiny, right? Now, let's try to understand the reason why author wants the judiciary to intervene in such laws. Now, let's try to understand what is presumption of validity. Now, the constitutional courts do not routinely interdict statutes or statutory rules, which means the constitutional courts, the Supreme Courts, High Courts do not prevent Parliament or let's say the state legislature from making laws. Do not declare the laws to be unconstitutional unless the law violates the constitutional principle, which means it is presumed that the law made by the Parliament or state legislature is valid, right? Which means the Supreme Court has stated that the legislative malice, which means it doesn't matter if the law is good or bad for the people, as long as the Parliament or let's say the state legislature is following the process to make a law, it is beyond the jurisdiction of the law courts unless it violates the constitutional principle. So, it is presumed that the law made in the Parliament or state legislature is valid. However, the author tries to highlight that this conventional wisdom is inadequate in contemporary times. Why? Because the populist regimes are driven by emotions, are driven by the popular emotions, which at times may violate the constitutional principle as well. That's the reason the author wants the judiciary to deviate from this conventional wisdom of presuming the law to be valid. And the author states that in case or if the judiciary doesn't refute or refuse to strike down such law, it will diminish the counter-majoritarian role of the constitutional courts. Again, the author tries to highlight that legislation or law which is made is inherently political statement, right? So, if they do not adhere to constitutional democracy, they should be striked down. So, judicial euphoria about the validity of laws has sometimes prevented the Supreme Court from banning harmful laws or striking down harmful laws. So, presumption of validity, which means the law which is made in the Parliament or state legislature is valid. It has prevented Supreme Court from intervening, right? Now, this is a case wherein the author tries to highlight that how despite a judgment given by the Supreme Court, the Parliament has overturned the judgment of the Supreme Court and has in a way violated the constitutional principle. Now, in Anup Baranwal versus Union of India case, the Constitution bench had called for an independent body to select the Election Commission of India, which means there should be no political interference. This was the judgment given by the Constitution bench of 5 judges. What did the Parliament do? The Parliament enacted a law to supersede the judgment of the Constitution bench, which means now the Prime Minister's committee, they choose the Election Commission of India. here we get to see political interference in the appointment of the Election Commissioner of India, right? And again, there were few flaws or there were few violations done by the current government, but the Election Commission of India refused to take any action against the current government. Is an example that the author is trying to give, stating that how political interference, it affects the stability and credibility of the Election Commission of India, right? Then again, talking about CA, the author tries to highlight that how CA targets a particular committee and violates the secular principle of our constitution. Then the author also tries to highlight this particular act which criminalizes triple talaq. The author tries to highlight that when the Supreme Court had invalidated triple talaq in the Shaira Bano case of 2017, what was the need for the Parliament to enact a law and criminalize triple talaq? Right? So this again is a question that the author has raised. The author tries to highlight that there should be no need to criminalize triple talaq. Then it's not that the judiciary has never intervened. The judiciary has intervened, for example, in the contentious farm laws. Now, when the 3 farm laws were made by the Parliament, the Supreme Court had given an order to stay the implementation of the farm laws, which means it isn't that the Supreme Court has never intervened. The Supreme Court has intervened. The author wants the Supreme Court or the constitutional courts to take more proactive stance and ensure that no law which violates the constitutional principle should be implemented. So, in the conclusion, the author tries to nudge the Supreme Court and state that the Supreme Court should learn from its track record and understand the political consequences of insensitivity, right? So, the author wants the Supreme Court to take strong, immediate and unambiguous judicial review, which is essential for addressing malicious and unconstitutional laws. Then again, the author wants the judiciary to act swiftly to mitigate, to reduce the political and social repercussions of divisive laws like the Citizenship Amendment Act. I hope students have understood the article, right? Students, the title of the next topic is Supreme Court to revisit 1995 order on suing doctors in Consumers Court, right? So again, in this article, you need to understand Consumer Protection Act, the Central Consumer Protection Authority, and you can map this topic under GS paper 2 under the topic, subtopic, important aspects of governance, right? So let's try to go through a previous question which was asked in the year 2012. Now here, there are few statements given on consumers or the rights of consumers, right? So the consumer rights or the privileges that are given to the consumers, right? So please go through these statements and try to answer the question. Now, what is the context? The context is the Supreme Court is considering to revisit a 1995 judgment, which means the Supreme Court had given a judgment in the year 1995, which was a judgment, we'll discuss it. Now, the Supreme Court wants to revisit the 1995 judgment, which means the Supreme Court wants to change the judgment that was given in the year 1995. What was the judgment? VP Shanta case was a judgment in the year 1995. Now, in the year 1995, the Supreme Court ruled that the medical professionals provide a service as defined in the Consumer Protection Act, which means as the medical professionals provide a service, people can file a case or people can file a lawsuit in the consumer court. Why? Because the medical professionals provide service, which means they were brought under the purview of the Consumer Protection Authority, which means if you are not satisfied with the services given by the medical professionals, you have the right to approach the consumer court to challenge or to raise complaint against the medical professionals. Now, the current debate questions whether the CPA could apply or should apply to medical professionals. The current debate. And why has the current debate arose or current question arose? Because of a ruling given by the Supreme Court in the month of May 2024, that is on May 14th, the Supreme Court held that or declared that professions such as lawyers cannot be sued under the Consumer Protection Act. So the question is, if the lawyers cannot be sued under the Consumer Protection Act, then how come the medical professionals like doctors can be sued under the CPA? The May 14 judgment of the Supreme Court in the year 2024 distinguished between professionals and those engaged in business or trade. It ruled that services provided by the professionals like lawyers and doctors are not the same as those provided by businessmen or traders, which means the Supreme Court judgment tries to highlight the position that the professionals cannot be brought under the CPA, that is Consumer Protection Act or authority, which means people cannot challenge the services provided by the lawyers and the medical professionals. As of now, yes, the doctors can be sued in the consumer court. This is what the Supreme Court wants to revisit the 1995 judgment. Now, in this context, it is important for you to understand the CPA Act of 1986, right? Now, the purpose of CPA Act of 1986 is to provide safeguards to whom? To consumers against various types of exploitation and unfair trade practices. For example, let's say a product which claims to remedy many diseases. Now, there is no evidence as to whether the product can actually remedy or provide a solution to various diseases. But in order to attract people, the marketing agencies or the products, they label the product in such a way so as to attract people to their product. So now this is an unfair trade practice. So in case you come across any product which claims to provide remedy to many diseases, for example, Patanjali, right? Now there's a case in the Supreme Court, or the Supreme Court has asked the Patanjali company to submit an apology letter. Why? Because the products of Patanjali claim that they provide a solution to many of the diseases. But the petitioners had filed a petition in the court stating that the Patanjali products do not remedy the diseases, and that's the reason the Supreme Court had informed the owners or founders of Patanjali to submit an apology letter. So no company can engage in unfair trade practices, cannot exploit people. That's the reason we have this Consumer Protection Authority Act. And in case you have to raise a complaint against any company or their products, then you have three platforms. One, the District Consumer Dispute Redressal Mechanism at the district level, the State Consumer Disputes Redressal Commission at the state level, and then we have the National Consumer Dispute Redressal Commission at the national level. So these commissions, they actually safeguard the consumers against the unfair trade practices and exploitation, right? Now, this act was amended in the year 2019. Now, this amended act, it replaces the original act of 1986. Why? So as to address the contemporary issues. For example, under the amended act of 2019, Central Consumer Protection Authority was established to protect and enforce the rights of the consumers and also to investigate and take action against unfair trade practices. It has expanded the definition of consumer, which means now under the definition of consumer, even the people who are engaged in e-commerce are included. Then they also enhance the penalties for misleading advertisements and unfair trade practices. So these were the provisions incorporated as per the 2019 Amended Act. Now, the CPA, it excludes services provided free of charge, which means if any company or let's say any professional, they are providing services for free, so such services are excluded from the CPA, right? So one, the services which are provided for free, and second, the contract of personal service, they are excluded from CPA. Now, there are three types of services in medical professions. One, free for everyone, which is excluded from CPA. Paid by everyone, which is included in CPA. Now, this regarding free for certain categories of people who cannot afford them. Now, here, the Supreme Court noted that the CPA has intended, or the intention of CPA was to protect all consumers. So, regardless of people are in a position to pay the amount for their medical expenses or not, the CPA intends to protect all the consumers, which means if you exclude free services from the definition of service under the CPA, then it would result in inequities. That's the reason the Supreme Court held that even this category, the third category, should be brought under the purview of CPA, which means the certain category of people who are not in a position to pay for their medical expenses, even such services, that is the services provided free of cost for certain category of people, even such services now are brought under the purview of CPA. Again, regarding the contract of personal service, the court held that the medical care, that is medical professional, does not constitute a contract of personal service. Why? Because the contract of personal service is limited only to employer and employee relationships. That's the reason, since there is no master-servant relationship between doctor and patient, the contract between medical practitioner and patient cannot be treated as a contract of personal service, right? So in conclusion, we have to wait and watch how the Supreme Court respond to the 1995 judgment, because this is going to reflect the ongoing debates about the responsibilities and liabilities of medical professionals. Though we are ready to buy the argument that if lawyers can be excluded under CPA, even the doctors should be excluded. But again, the doctors, the medical professionals have certain responsibilities, certain liabilities which needs to be taken care of. I hope students you understood the article. Students, the title of the next topic is Barriers to Entry, Platform Neutrality and Algorithmic Collusions, right? So these are all the terms that you need to understand: e-commerce, platform neutrality, algorithmic collusion, and this you can map under GS paper 2 as well as GS paper 3. So a question was asked in the year 2018 on Digital India plan of the Government of India. So a question of this nature can be asked in the examination, right? Now, what is the context? The context is that the chairperson of the Competition Commission of India has highlighted concerns over the control of digital platforms like Amazon, Google, Flipkart, or large data sets. Now, the control of the digital platforms or large data sets can create barriers like entry for new players in the competition, second, compromising platform neutrality, and it also leads to algorithmic collusion. So this were the words used by the chairperson of the Competition Commission of India. So let's try to understand each of these terms. The first is barriers to entry. Now, control over large data sets by the digital platforms creates barriers for entry for the new players. How? For example, companies like Amazon and Flipkart, what they do is they collect and leverage the data, right? And through this, they gain significant competitive advantages. You know that data is a gold mine in this days, right? So these companies have the access to lots of data, hosts of data, and they try to leverage this data and try to gain significant advantage. They leverage the data to improve these services. Then they create personalized offerings, optimize their operations, and this the new players cannot do. Why? Because the new players they do not have that data through which they can leverage the data to create personalized offerings for the customers. So this is barriers to enter. This is the first point. The second point, platform neutrality. Now, when digital platforms like Google, the problem arises when the digital platforms like Google compete with businesses relying on their infrastructure. For example, other companies have to rely on Google for the business. Now here, Google is also creating its own product. They are competing with other companies who are relying on their infrastructure. Now there are high chances that the Google may favor their services or products, or Google may prioritize their own products or those of their partners, which means the new players simply do not have that space where they can compete. The third is algorithmic collusions. Now, for example, companies like Make My Trip, GoIbibo, they shape the user experiences and make pricing and product placement decisions. How? By using algorithms. Now, the opacity of algorithms, the unclarity of algorithms make it challenging to assess their impact on competition. What is algorithmic collusion? Where algorithms might coordinate prices or strategies without human direction. So, at times you get to see the prices. Let's say, for example, you're searching a hotel, or let's say you're searching a product. Now, the algorithms are placed in such a way that in some time, or in a matter of few time, the prices of, let's say, the product that you're searching for, it inflates. So, this is the result or consequence of algorithmic collusion, and this will reduce competition. Now, students, in this context, in order to prevent such unfair trade practices, or in order to create level playing field, it is important to understand the importance of Competition Commission of India, which is a statutory body which was enacted through this Act of 2002. What it does is, it prevents practices that have an adverse effect on competition. It promotes and sustains competition in market and protect the interests of the consumers. Then it is also responsible for investigating and taking action against anti-competitive agreements. So, anyone who is engaging in anti-competitive agreements, trying to create a monopoly, the CCA is responsible to investigate and bring these companies to justice. Now, one of the key roles of the company is to protect consumer interests by ensuring fair competition. This is what we have discussed, right? Now, India has drafted national e-commerce policy, and it was shared among the public in the year 2019. The final draft is yet to come, but again, whenever the final draft would appear, would come, it would include, it would rope in, it would take into consideration stricter consumer protections and data localization rules, so that the digital platforms do not leverage the benefit or advantage that they have and create level playing field. I hope students here understood the article. Students, the title of the next topic is both competition and level of playing field is important for EV sector. So, under this topic, you need to understand few key terms like electric vehicles, environmental conservation, infrastructure, and energy, right? Again, this topic is important both for prelims and mains. So, a previous question was asked in the year 2019, and the question was, how is efficient and affordable urban mass transport key to rapid economic development in India? Now, as the electric vehicle sales is going up in our country, we need to understand the challenges that the EV sector faces in our country, the opportunities, right? So, let's get started. Now, MG Motor, which is one of the companies in India, has recorded 30% of its sales volume coming from the electric vehicles, right? So, which means that the sale of electric vehicles in our country is growing up or going up year on year. Now, let's try to understand electric vehicles. Now, electric vehicles are automobiles that are propelled by one or more electric motors. Now, they use energy which are stored in the rechargeable batteries, right? So, as we all know, the electric vehicles are considered more environment friendly as compared to the conventional vehicles because they typically emit less greenhouse gases and pollutants, right? So, now let us try to understand the Government of India schemes and policies to promote the electric vehicles in our country. First is the FAME scheme. FAME stands for the Faster Adoption and Manufacturing of Hybrid and Electric Vehicle scheme, which was launched in the year 2015, and the second version of FAME was launched in the year 2019. It aims electrification of public and shared transportation. How? Through subsidies for electric buses, three-wheelers and four-wheelers. So, if you go to buy a electric vehicle, you would get subsidy from the government. So, government wants the consumers to buy more and more electric vehicles because it emits less greenhouse gases. Then we also have National Electric Mobility Mission Plan, which was launched in the year 2013. It aims to achieve national fuel security. How? By promoting hybrid and electric vehicles. The plan targets 6 to 7 million sales of hybrid and electric vehicles by 2020. Then we have the production linked incentive scheme. Now this scheme the government of India has launched in order to boost the domestic manufacturing and reduce the import dependence, right? And this PLI scheme is also introduced for the EVs, that is electric vehicles. Now, what are the implementation and challenges? First is the high initial cost. Now, as compared to the other vehicles which are run on petrol and diesel, the EVs are more costlier, right? Because of the high initial cost, or because the spare parts, right, or the materials that is required to make an EVs are more costly in nature. So next challenge is infrastructure deficit. Now, when it comes to infrastructure deficit, you rarely find charging infrastructure or charging facilities, right? So this again is a problem that the EV vehicles face in a country. Then the battery technology. Now the batteries that are used in the EVs are imported from other countries, which means there's import dependence, and that again is a problem. Why? Because the raw material that is used in the batteries, that is lithium, is not found in a country. It's not found in a country in major quantity. That's the reason we have to depend on the other countries to import lithium. Then range anxiety. Now the EVs, once they're fully charged, they can run up to maximum 200 to 250 kilometers. Beyond that, it needs recharge. So let's say, for example, a person has to travel from one city to other city. The range of the EVs is not sufficient for that person to use EVs to commute intercity, right? So this is another challenge. Now, Chile, Bolivia and Argentina, they form a part of lithium triangle, which means these are the three countries where lithium is found abundantly as compared to other countries. So again, way forward, again the government of India has to provide policy support. How? By subsidies and incentives to the companies that are in the EV sector. Then investment has to be there so as to develop advanced batteries and reduce import dependence. Then public and private partnership has to exist so as to build robust infrastructure like the recharging points, right? And then consumer awareness. Again, consumer awareness is required so that more and more consumers buy the electric vehicles. So I hope students you understood. I hope students you understood the article, right? Students, the title of the next topic is Antarctic Parliament meets in Kochi. So in this context, you need to understand Antarctica Treaty and Antarctica Parliament. You can map this topic under GS paper 3, Conservation, Environmental, Pollution and Degradation, right? So this was a question asked in the year 2015. The term in arc, sometimes seen in the news, is a name of. So such terms, whenever it appears in the examination or in the newspaper, just be careful and try to find out the significance of that term, right? So these are the four options. Now, the context is that India is presiding over the 46th Antarctica Treaty meeting, which is going to be held in the Indian city of Kochi from May 20 to May 30. This event is organized by National Center for Polar and Ocean Research and Ministry of Earth Sciences. It is going to be attended by 56 countries. So this point becomes important for your prelims examination. Now again, this points, what is Antarctica Treaty, can be asked in your pre-examination. So it was established in the year 1959, effect 1961. It declares that the continent Antarctica will be used only for peaceful and scientific purpose, and it will not be used for militarization and nuclear activities, right? So purpose is to promote scientific freedom, cooperative research and data sharing, which can benefit the human mankind, right? It has 56 member nations. So the Antarctica Parliament or the Antarctica Treaty Consultative Meeting is an annual gathering of the parties to the 1959, which means the meeting takes place annually, right? The primary goal is to share information, discuss issues of mutual interest. Now from 1961 to 1994, the meeting used to happen once in 2 years, but from 1994 onwards, the meeting happens every year. Participants, it had originally 12 signatories and other nations that conduct significant research in Antarctica like India. Now the participants include consultative parties and non-consultative parties. Now, consultative parties are the ones, the 12 signatories and other nations who carry out research in the continent, and the other is non-consultative parties, right? Then we have observers and experts, for example, like the organizations like the Scientific Committee on Antarctica Research and International Association of Antarctica Tour Operators, right? These are the observers and experts. Now, hosting duties, it rotates among the consultative partners, which means it rotates alphabetically, right? Now, decision making is done through measures, decisions, and resolution. Now, measures are legally binding. The decisions are not legally binding, which means some decisions are legally binding, some are not legally binding. Now, this meeting, the agenda for this meeting, this year's meeting, will include discussions on legal frameworks, logistical support, and the governance of scientific activities. Key topics include sustainable resource management, biodiversity, research collaboration, and the impact of climate change on Antarctica. Now, talking about India's role and contribution in the Antarctica research. Now, India is a consultative member since 1983. India's missions were active in Antarctica, and those were Dakshin, Gangotri, and Maitri. Now, these are the stations that India has in the Antarctica continent, and these are the stations that we use for the research purpose. Now, India's upcoming project, that is Maitri 2, which is going to be operational by 2019, undergoes India's commitment for scientific exploration of Antarctica continent, right? India is also going to propose this year working group to regulate Antarctica tourism, which is supported by countries like Netherlands and Norway to enhance sustainability and mitigate environmental impacts, right? This is India's role in the Antarctica research, right? So I hope students you understood the article. Students, now is the time to discuss few practice questions. So let's get started. Question number 1, consider the following statements about the lithium triangle, right? Now, first statement, again, you can pause the video and read all the statements and try to answer the question. Okay? Now, the first statement, the lithium triangle is located in South America and includes parts of Chile, Argentina, and Bolivia. Yes, this statement is correct. This is what we discussed, right? The region contains a major portion. Which region? Lithium triangle. Major portion of the world's lithium reserves essential for EV vehicles, right? Even this is correct. The lithium triangle countries are part of the European Union and have jointly developed policies for lithium extraction. This is incorrect. All these countries are part of South America. So there's no question of these countries being a part of European Union, which means how many of the above statements are correct? Only 2 statements, 1 and 2. The next question with reference to Antarctica Treaty Consultative Meeting, right? Now, this is a biennial gathering of the parties to the 1959 wrong. This is an annual gathering. So, this is incorrect. All the decisions made in the meeting are binding on its members. No, some are binding, some are non-binding. So, even this is incorrect, which means option D has to be the correct answer. Next question is, which one of the following statement best describes algorithmic collusion? Now, it is a synchronization of business strategies between companies using data analytics for market research. It refers to the use of algorithms to make collaborative space missions. No way. It involves the coordination of pricing and product placement decisions by algorithms, potentially without human intervention, leading to, yes, this is correct. See, this is what we discussed in the topic, right? So, option C is the correct answer. Fourth, regarding CAA 2019. Now, it provides a pathway to Indian citizenship for undocumented migrants from 1 to countries belonging to specific religious. These are 6 countries, right? 6 religions from 3 countries. So, this is correct. It reduces the requirement for citizenship eligibility from 11. No, this is 5 years. Reduces from 7 to 5 years through naturalization. Applicants must declare their country of origin and provide documents tracing the routes to the specified countries. Yes. Fourth, the final authority to grant a citizenship rests with the director's census operation. Even this is correct. So, 1, 3 and 4 has to be the correct. Option B is the correct answer. Next question with reference to Competition Commission of India. Now, the Competition Commission of India is responsible for preventing practices that have an adverse effect on competition of India. This is correct. The orders of Competition Commission of India can't be challenged. Wrong. This can be challenged. So this is wrong. The Competition Commission of India does not conduct market studies. Wrong. They will. They have the authority to conduct market studies and give directions. Even so, this one is incorrect. Which of the statements given above are incorrect? So incorrect is 2 and 3. Option C is the correct answer, right? Now the means practice question. Question is main challenges in effectively safeguarding consumer rights and how they can be tackled through policy measures and institutional reforms. So in the introduction, you should mention the challenges that the consumers are facing, right? So this issue stems from various systematic and operational deficiencies for which you need to provide solution in the body of the answer, right? So it requires a comprehensive approach involving policy intervention and institutional reforms, right? So in the body, you can mention the challenges first. 1, awareness and education is lacking among the consumers. That's the reason they do not know which institution to approach in case they are subject to any fraud practice. Then enforcement and implementation, even if they register the complaint, for enforcement and implementation, it takes a lot of time. Judicial delays, the consumer courts where the cases are eventually filed, they are plagued or they are burdened with backlogs, due to which it takes time to give judgment. And then digital market issues, because of the rapid growth of e-commerce, it presents new challenges, right? These are some of the challenges. Then how do we find a solution? By enhanced consumer education. So awareness is the key. So we have to ensure that awareness should exist so that consumers should understand the rights that they have. Then you have to strengthen the laws so as to address the contemporary issues, especially in the digital space or platforms. Then you have to establish clear regulation for emerging markets like e-commerce so that the contemporary issues are also addressed. Then institutional reforms. We have to ensure that the capacity of consumer courts is enhanced or increased. How? By increasing staffing, resources and training for efficient case handling. Then you have to leverage the technology to streamline process in the consumer court so that the judgments can be declared as soon as possible, right? And it has to improve transparency as well. Then we need to have dedicated agencies like the Consumer Protection Authority Agency, right? So they can focus on specific issues such as digital consumer protection and market surveillance, right? And finally, you can conclude the answer by highlighting that it is very important to protect the rights of the consumers. For that, the institutional protection has to be there, the policy intervention has to be there, and ultimately the government working with the NGOs and different organizations have to ensure that the rights of the consumers are protected in our country, right? I hope students have understood how to write the mains answer. So that's it from our daily news analysis session, students. I hope you understood all the 5 articles that we have discussed in today's session, students. Students, if you want us to continue with our DNA session, then please do like, share and subscribe to Narayana IS channel. Thank you so much.